for lawful purposes. And so there have been historical regulations on weapons like Bowie knives or billy clubs or
to do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing. Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Breaking news, Supreme Court is making some serious decisions regarding guns, but is there any final decision yet? Supreme Court's Second Amendment decision sparks confusion and legal challenges. A precedent-setting decision by the U.S. Supreme Court about the Second Amendment is currently overturning gun laws all around the country, causing disagreement among judges and sowing confusion regarding which firearm restrictions can still be in effect. According to experts, the decision of the High Court that established new criteria for analyzing gun regulations left many questions unanswered, which has led to an increase in the number of inconsistent decisions made by lower court judges as they attempt to determine how to apply the standard. Because of the so-called Bruin judgment, lower courts no longer apply the same standard to determine whether or not an individual's appeal to a handgun prohibition should be upheld. The court has decided that judges should no longer be required to evaluate whether or not a legislation serves public objectives, such as improving public safety. In accordance with the new standard established by the Supreme Court, any government that wants to maintain an existing gun control measure will be required to demonstrate that the measure is in keeping with the historical tradition of firearm regulation in the U.S. In recent weeks, a number of federal regulations that were enacted with the intention of preventing domestic abusers, felony defendants, and marijuana users from possessing firearms have been ruled unlawful by the courts. The enforcement of Delaware's ban on the possession of homemade ghost guns has been delayed by the judiciary, and a federal ban on owning guns with the serial numbers removed and limitations on gun ownership for young adults in Texas have also been struck down by the courts. As a result of the decision made by a majority of the conservative justices on the Supreme Court, various cases have occurred in which judges who have examined the identical statutes have reached conflicting conclusions regarding the constitutionality of those laws. The Supreme Court will almost certainly have to step in again in the near future to provide further advice for lower courts as a result of the legal upheaval that was generated by the first major gun ruling in 10 years. There's confusion and disarray in the lower courts because not only are they not reaching the same conclusions, but they're just applying different methods of applying Bruin's method differently, said Jacob Charles, a professor at Pepperdine University's law school who focuses on weapons law.
Weapons ban is constitutional. So we know dangerous and unusual weapons are outside the scope altogether, but even if analogous historical tradition of regulating weapons that would make an assault weapons ban constitutional change so significantly since 1791.
So yes, just a bit, right? So dangerous.
Just a bit. Still consistent with the Second Amendment, even on the Supreme Court's reading of what it includes. And so I think it finds that reasoning persuasive. The things like analogies to regulations of Bowie knives and billy clubs sort of binding on the nation as a whole. And I think it's unclear about how some of the justices specifically.
Charles is a member of the National Association of Criminal Defense Lawyers. What it means is that not only are new laws being struck down, but also laws that have been on the books for over 60 years, 40 years in some cases, those are being struck down, he added. Before Bruin, courts were unanimous that these were constitutional. The legal wrangling is taking place while law enforcement officials all around the U.S. are working to combat an increase in the number of violent crimes that have been committed and while mass slayings continue to haunt a society that is awash in guns. 6 people were brutally slayed at numerous sites in a small town in rural Mississippi, and a slayer ended 3 students and badly wounded 5 more at Michigan State University before turning the pistol on himself. At this point in 2023, there have already been multiple mass slayings that have resulted in the endings of dozens of people. One of these massacres took place in California, where 11 individuals lost their lives while celebrating the Lunar New Year at a dance hall frequented by senior Asian Americans. According to the Gun Violence Archive, there were more than 600 slaying incidents in the U.S., in which at least 4 persons were slayed or wounded in the past year. These incidents occurred around the country. The judgment paved the way for a slew of legal challenges to be brought by gun rights enthusiasts, who saw an opportunity to overturn regulations governing everything from age limitations to semi-auto rifles in the form of an AR-15. The ruling in Bruin, which abolished what proponents of gun rights consider to be unlawful limits on Second Amendment rights, was seen as a positive development by those who advocate for the right to bear arms. Debate and impact of recent Supreme Court Second Amendment ruling. Mark Oliva, a spokesman for the National Shooting Sports Foundation, described this interpretation of the Constitution and the Bill of Rights as a true reading of what the Constitution and the Bill of Rights tells us. When it comes to our fundamental rights, it unequivocally does provide clarity to the lower courts on how the Constitution should be applied. Concerns have been raised by organizations that seek to restrict access to firearms following a ruling by a federal appeals court that, according to the new criteria established by the Supreme Court, the government is unable to prevent individuals who are the subject of a domestic violence restraining order from having firearms.
Figures. And this is something that we should celebrate, that today's gun owner is looking a little bit less like me and more like the rest of America, with crime in America, not with law-abiding gun owners.
We have talked much of this show about the fact that crime is going. It seems like a fairly strong statement. Do you still stand by that, Mark?
Joe Biden stood on the debate stage with all the other Democratic candidates and said, the firearm industry is the enemy. Uphold and defend the Constitution. And he's calling me and my industry, which provides the law enforcement and the military their fire. All the policies that he's laid out are demonstrating that he is doing everything that he will to destroy this industry.
The examination administered by the Supreme Court has sparked debate about whether or not judges are qualified to pore into historical records and whether or not it is logical to evaluate contemporary legislation based on restrictions, or the lack thereof, that existed in the past. We cannot claim to be experts on the subject of the opinions held by white, wealthy male property owners in 1791 regarding the regulation of firearms. However, in the name of constitutional adjudication, we are now supposed to assume the role of historians, wrote U.S. District Judge Carlton Reeves of Mississippi, who was chosen by former President Barack Obama. Some judges are really parsing the history very closely and saying these laws aren't analogous because the historical law worked in a slightly different fashion than the modern law, according to Andrew Willinger, the executive director of the Duke Center for Firearms Law. He mentioned that some people have done a much more flexible inquiry and are trying to say, look, what is the purpose of this historical law as best I can understand it? Both proponents and opponents of gun control are keeping a careful eye on a number of pending legal challenges, including those that seek to overturn state laws that prohibit certain semi-auto rifles and high-capacity mags. A legislation in Illinois that prohibits the sale of so-called assault weapons and high-capacity mags was found to be constitutional by a federal judge in Chicago. The judge ruled that the law complied with the Supreme Court's new test for determining whether or not a statute is constitutional. In the midst of a separate legal action, a state court has already partially halted the law, which allows certain gun dealers to continue selling the guns. This was done in response to the fact that the law was being challenged. Already, several of the gun legislation that were created in response to the ruling made by the Supreme Court have been struck down. A judge ruled that many parts of New York's recently enacted gun law violate the state's constitution. These parts include the regulations that prohibit the carrying of firearms in public parks and places of worship. After some time had passed, an appeals court put a hold on that ruling while it considered the matter. In addition, the Supreme Court has given New York permission to continue enforcing the legislation for the time being. While some judges have supported a provision that prohibits those who are under indictment for felonies from purchasing firearms, others have ruled that the law violates the Constitution and have struck it down. Challenges to long-standing gun restrictions. Because a person is the subject of a domestic violence restraining order does not mean that the federal law can prohibit that person from owning a gun. This was the ruling of one court. Another court has concluded that it is a violation of a person's constitutional right to own a firearm if they have been convicted of a felony that does not involve violence. And a third judge ruled that the federal statute that prohibits persons under the age of 21 from owning firearms is unconstitutional. All of these recent rulings by lower federal courts are the result of court decisions that have struck blows against long-standing federal gun restrictions. These court decisions were issued by lower court judges in the past year after the Supreme Court, in a sweeping ruling, expanded gun rights by finding for the first time that the Constitution's Second Amendment right to bear arms extends outside the home. In other words, the Supreme Court found that the right to bear arms under the Constitution extends outside the home.
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here, a defense of the Second Amendment, which this most certainly is.
Twine says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself.
Because people buy hundreds of guns legally and then they sell them illegally.
A flurry of challenges to long-standing laws, both federal and state, have been triggered as a result of the decision made by the conservative majority of the Supreme Court, which is 6-3, and some judges have found that they are invalid in light of the new standard. There are now multiple interpretations of the law throughout the country as a result of other courts' decisions to uphold gun prohibitions. It has also led to blue states implementing a new wave of gun legislation in the hope that they will not fall foul of the Supreme Court's rationale. This has resulted to an increase in the overall number of gun slayings in the U.S. Now the matter is once again at the doorway of the Supreme Court, as the Biden administration has asked the court to restore the verdict of a lower court that invalidated the federal law that prohibits those who are subject to domestic violence restraining orders from acquiring weapons. The justices are going to meet behind closed doors to consider whether or not they will hear the case. This will be the first true test of how broadly the court's conservative majority wants its rule from 2022 to be interpreted. The new standard that was established by the Supreme Court in the case of New York State Rifle and Pistol Association versus Bruin mandates that courts give their full attention to determining whether or not a legislation is consistent with a historical interpretation of the Second Amendment. In rendering their decision in the case of Bruin, the conservative majority gave every indication that they were troubled by the fact that lower courts had not shown a greater degree of skepticism regarding gun regulations in the years following the previous key gun rights verdict that the Supreme Court issued in 2008. The immediate impact of the Bruin decision gives the impression that lower courts, which have become increasingly conservative in recent years as a direct result of the appointments made by former President Donald Trump, have this time appeared to comprehend the significance of the situation. Jake Charles, an expert in weapons law at Pepperdine University's law school, is quoted in an article as saying, "Now we see not only more decisions more quickly, but we see decisions striking down laws not thought to raise serious Second Amendment problems in the first place." Domestic violence claims. A crucial battlefield is on a series of federal restrictions that are stated in a piece of law called 18 U.S. Code Piece 922. Gun rights supporters have taken aim at state and municipal restrictions in the aftermath of the Supreme Court verdict, but one of the most important battlegrounds is on these federal limits. One of these sections, designated as 922G8, applies to anyone who is subject to a court order because it was determined that they posed a risk to the safety of a domestic partner or child. One such individual is Zaki Rahimi, who is alleged to be a drug dealer in the state of Texas and whose partner received a restraining order against him in February of 2020. During an incident that took place in a parking lot in Arlington, Texas the previous year, the federal government recalled the details of the event in court documents. Rahimi was accused of hitting the woman to the ground, dragging her to his car, and putting her inside, causing her to hit her head on the dashboard in the process. It is also reported that he fired a shot from his gun after learning that an onlooker was observing the incident. During the time that the protection order was in force, Rahimi was accused of being involved in a number of slayings, including one event in which he allegedly used an AR-15 weapon to fire rounds into a residence. The federal government says that this incident occurred. The state brought charges against Rahimi for both the domestic assault and the other incident, which was committed against a different lady. He was tried separately for violating the federal gun restriction legislation, and prior to the Supreme Court issuing its new rule on gun rights, he contended that the case should be dismissed due to his right to bear guns under the Second Amendment.
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
But for me, and for most of you, here's what it really is. It's an important first step.
I'll be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
The allegation was shot down by a federal judge, who pointed out that the legislation had been upheld in previous cases. The Fifth United States Circuit Court of Appeals in New Orleans, which was hearing the appeal, initially came to the same result. Afterwards, the Supreme Court handed down its verdict in the Bruen case. As a consequence of this, the appeals court considered more briefing and then quickly reversed course, coming to the conclusion in March that due to the expansion of gun rights, the statute fails to pass constitutional muster. The Biden administration has requested that the Supreme Court examine Rahimi's case, with Solicitor General Elizabeth Prelogar stating in court documents that the finding of the appellate court was profoundly mistaken. She stated that the ruling poses a significant risk of grave harm to victims of domestic violence. Even when considering the Bruen standard, Prelogar believes that the legislation ought to be respected because there is a historical tradition of the government disarming individuals who pose a threat to the safety of others. During this time, however, challenges to many other aspects of federal law are gaining traction in lower courts. In the beginning, the Third Circuit Court of Appeals in Philadelphia, which is located in Pennsylvania, took aim at another rule known as 922G1, which forbids convicted felons from having firearms. The court came to the conclusion that the statute violated the Constitution when it was applied to individuals convicted of nonviolent offenses. The court stated that there was no historical practice of people being disarmed after being convicted of nonviolent offenses, which was the basis for reaching this determination. Other judgments on different sections, including ones that prevent those who are already under indictment for a felony and users of illegal narcotics from carrying firearms, have followed a pattern that is analogous to this one. Federal gun laws targeted. Since the Supreme Court's Bruen ruling, judges have ruled in favor of challenges to many long-standing federal gun restrictions under 18 U.S.C. 922. Recent court decisions have challenged long-standing federal gun restrictions, raising questions about the constitutionality of certain provisions under the Second Amendment. Here's a breakdown of specific challenges and rulings. People under 21, 922B1 and related provisions. A judge in Virginia ruled in favor of a challenge to a law that prevents individuals under 21 from purchasing firearms. This ruling questions the validity of the restriction based on age. Nonviolent felons, 922G1. A Philadelphia-based appeals court held that a law prohibiting felons from possessing firearms could not be applied to nonviolent felons. This decision challenges the broad prohibition against firearm ownership for all felons, regardless of the nature of their convictions. Drug users, 922G3. A court in Texas ruled that preventing illegal drug users from possessing firearms violates the Second Amendment. This ruling highlights the tension between public safety concerns and individual gun ownership rights. Domestic violence offenders, 922G8. An appeals court in New Orleans ruled that prohibiting individuals subject to domestic violence protection orders from owning firearms is unconstitutional. This decision delves into the balance between protecting victims and individuals' gun rights. Firearm serial numbers, 922K. A West Virginia court declared that banning firearms with removed serial numbers or ghost guns is unconstitutional. This ruling addresses the intersection of technology, regulation, and the Second Amendment.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
People under indictment, 922N. In various cases, including one in Texas, judges have ruled that individuals under felony indictment cannot be barred from gun ownership. This challenge touches on the presumption of innocence and the right to bear arms during legal proceedings. These rulings collectively challenge the prevailing interpretations of federal gun restrictions, emphasizing the evolving nature of Second Amendment jurisprudence. While these cases focus on specific provisions, they contribute to a broader conversation about the balance between individual rights and public safety concerns. Because the Bruen case has produced such varying outcomes in lower courts, it is universally agreed upon that the Supreme Court ought to hear the Rahimi case. This is the consensus of proponents of both gun control and gun rights. "We would be thrilled to get further clarification from the court on these issues," said William Sack, a lawyer with the Firearms Policy Coalition, a group that advocates for the right to bear arms. Those who advocate for stricter gun control are keeping their fingers crossed that a majority of the Supreme Court would preserve time-honored regulations such as the one that is currently being challenged in the Rahimi case. In order to avoid having to overrule the Bruen decision, the court would have to determine that the restrictions in question are in line with how the Second Amendment has traditionally been interpreted. Gaining the support of Chief Justice John Roberts and Justice Brett Kavanaugh is likely necessary for success on this front. Although both Roberts and Kavanaugh were members of the conservative majority of the court in the Bruen case, Kavanaugh submitted a separate concurring opinion that was joined by Roberts. In this opinion, Kavanaugh described what he called the limits of the court's decision, making it apparent that the Second Amendment does allow for gun regulations. Roberts joined Kavanaugh in this position. Kavanaugh, referring to earlier court rulings, singled out the limitation on the possession of firearms by felons and those with mental conditions as an example of a rule that was not in jeopardy of being overturned. Reinstating ghost gun rule. By overturning a lower court decision, the U.S. Supreme Court has temporarily reinstated a rule that targets the proliferation of ghost guns, or firearms without serial numbers. Recent ruling by the nation's highest court, which was decided by a razor-thin margin of 5-4, upheld restrictions on ghost guns, weapons that can be built from separate parts or assembled using 3D printers that were put in place by President Joe Biden's administration. However, while the government appeals the lower court's finding, the ruling is merely provisional. Businesses and those who support gun rights had contested the new law, claiming the ghost gun limitation would go against the right to bear arms guaranteed by the Second Amendment. The top Supreme Court lawyer for the Biden administration, Solicitor General Elizabeth Prelogar, contended that those groups wouldn't be harmed by the temporary reinstatement of the ghost gun regulation. She stated in a court document that the public safety interests in halting the flow of ghost guns to dangerous and other prohibited persons easily outweighs the minor costs that respondents will incur. According to the U.S. Department of Justice, more than 19,000 ghost guns were found during criminal investigations in 2021, a tenfold rise in just over 5 years. The Biden administration's new rule, which was published last year, broadened the federal definition of a weapon to include unfinished gun parts used in ghost guns. In order to more easily trace the parts, that in turn required license and serial numbers for the components. The law does not prohibit people from purchasing toolkits that can be used to build guns. Instead, it mandates that producers do background checks before sales, as they do with the majority of commercially available weapons. Strong support for these limitations was found in a Reuters Ipsos poll, with 70% of respondents agreeing that ghost guns should be forced to have serial numbers and should only be manufactured by approved manufacturers. It's common sense. Ghost guns are guns, and they should be serialized and regulated as such, the pro-gun control organization Giffords wrote in a social media post. In defense of the administration's rule, it had submitted an amicus brief. However, U.S. District Judge Reed O'Connor overturned the Biden administration's regulation in June, claiming it went beyond the scope of the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives power. Following the Biden administration's request for a temporary injunction on the lower court decision, attorneys representing pro-gun and business advocacy groups presented comparable arguments before the Supreme Court. They claimed the Bureau was not adhering to accepted regulatory standards. However, the Supreme Court on Tuesday upheld the Biden administration's request despite having a 6-3 majority that was firmly conservative. John Roberts and Amy Coney Barrett, two conservative justices, joined the court's 3 liberal justices in allowing the order to stand while an appeal was being heard in New Orleans' 5th U.S. Circuit Court of Appeals. Despite worries about public safety, the Supreme Court has decided to scale back gun control laws in other cases. The court's decision to limit lawmakers' authority to prohibit the carrying of firearms in public places in June 2022 stoked the enthusiasm of pro-gun organizations and sparked a movement to repeal existing laws. With all the cases, the final decision is about to be made, and the situation is showing that it's going to be bad. That's all for this video, folks. See you next time.